counsel, are you ready to proceed?
We are. Well, as soon as Mr. Webb is brought in. Maybe there. Thank you.
I'm not totally sure.
Yeah.
Okay.
All rise. Washington County Trial Court is now in session. The Honorable Darlene O'Brien presiding.
Good morning. Please be seated.
Number one, People versus Kenneth Webb, 86-20874 FC.
Good morning, Your Honor. Lindsay Abramson on behalf of the people.
Good morning.
Hi, good morning, Your Honor. I'm David Moran from the Michigan Innocence Clinic, University of Michigan Law School, on behalf of Mr. Webb. And I'm joined by student attorneys Ania Vogel and Brittany Warren. And I'll be moving to have Ms. Warren participate in today's hearing under 8.120.
Good morning. And you're welcome to take your mask off when you're talking on the record so we get an accurate record of what's said.
Thank you, Your Honor.
Okay. So we have some individuals participating by Zoom also, I see, and I want to thank everyone for wearing their mask today. Masks are required, though, in my courtroom, unless you're talking on the record. Do we have masks for? Okay. We're trying to keep everyone as safe as possible, so. Do you have two for transport?
Should be masks right
Oh.
over there. On the...
Thank you.
Okay, thank you. So who would like to begin?
I'm sorry, Your Honor.
Would you like to begin?
Sure.
Okay,
Your Honor, first of all, I just want to say this
if
is.
you wouldn't mind using the podium, that way
Sure.
we've got the microphone
Of
right
course.
there. Thank
That
you.
makes sense. I didn't realize this one wasn't on. I'm sorry. Your Honor, this is, of course, one of the most, if not the most solemn occasion that we can have in the courtroom in the criminal justice system. There is, and I am the director of the Conviction Integrity Unit here at the prosecutor's office. Our jobs as prosecutors is, of course, to, number one, seek truth and justice. And our unit and our office recognizes that sometimes, horrifically, unfortunately, things go horribly wrong. And tragically, this is one of those cases. We have, before I get into, and I really am going to rest mostly on my motion, but I just want to say a couple of things first. There are no words that can express the sorrow and dismay for what has happened to Mr. Webb. And it sounds hollow coming from us, but it still needs to be said. We are incredibly, deeply sorry. There is nothing more than we can that we can say to make this better for anyone. This is awful, and we are so sorry to him. I also want to recognize what happens and the effect on the victims in this case as well. Because when we have to come forward as ministers of justice and seek to vacate any conviction, let alone a homicide conviction, this also destroys the families. Many families, including the families of the victims, including the victims. And I am deeply, deeply sorry to them for having to bring up all of this again when they thought this was all settled and done and closed. I want the court to know that I have had, myself and the victim advocates have had many conversations over the last several weeks, some within the last 24 hours with the victims in this case. I have spoken with I've spoken with the ex-wife of the victim. She was the wife of the victim at the time he was murdered. I have now spoken with the son of the victim. I have spoken with the brother of the victim, who I think might be joining us by Zoom or was. And this has, of course, been a deeply, deeply horrific experience for them to relive this. Regardless of that, we do believe, as we stated in our stipulated motion with the Michigan Innocence Clinic, with Mr. Moran, we believe it is absolutely necessary for justice to vacate this conviction against Mr. Webb and to dismiss the case without prejudice. This is, of course, something that we have thoroughly investigated. I started this position over the summer almost 5 months ago, but this investigation in this case was already well underway. It was led by our prior director, Francis Walters, who prior to that job was the director of the Mid-Atlantic Innocence Clinic. Her and I have both investigated the case thoroughly, and we have come to the same conclusions for the same reasons. This case was unfortunately a really tragic storm of errors by the state, and the new evidence. We believe the conviction, we simply cannot stand by the integrity of the conviction as the prosecutor's office. So that is number one today. Number two, we do believe, we cannot say absolutely for sure, but we do believe, based on our investigation, that the evidence in the case, the new evidence, points significantly to Mr. Webb being actually innocent of this crime. I can't say that 100% for sure, but our investigation has revealed that. There were several things that the jury didn't hear in this trial that we now believe they should have heard. And I'm not faulting anyone specifically. This was, of course, in the mid-'80s, and everyone did, when the trial happened, and everyone did the best that they could at the time with the information that we had and the studies that we had. But since the trial, first of all, we think the alibi in the case was incredibly strong to begin with. And the studies on false confessions now show when a jury is presented with a confession, that confession usually can override other evidence in the case. And we believe that likely did happen in this case. I've read through the transcripts thoroughly of every part of the trial, and the prosecution, our office did argue heavily that the confession just outweighs everything else. And we now know through social scientific research, false confessions do exist. And we do believe that that likely happened in this case, and we believe that for a number of reasons. The first thing I want to note about the confession is we stated in our stipulation, it simply wasn't recorded. So we don't know exactly what happened. We do know now that both of those officers are severely discredited for the reasons stated in the motion. We will never know exactly what happened in that room, but we do know that Mr. Webb suffers significantly from mental health issues. We know that he was under the influence that night. We know very likely he had been up for, we can't say for sure, but we think about 24 hours. And now with the new evaluation, the new evidence in this case, which was done on October 5th of this year, a psychiatric evaluation that both myself and Mr. Moran agreed to. We did an IQ test because IQ scores do heavily correlate with reliability of the confession. And we agreed on the provider. This was a respected provider. And the IQ score in this case for Mr. Webb is 53. To me, as an officer of the court, and with my experience, quite frankly, as a prior defense attorney in death penalty cases, who's very familiar with IQs and the effect that that can have on interrogations, this IQ number is shockingly low, and someone with Mr. Webb's intellectual capacities would have an extremely hard time saying anything in an interrogation, let alone a reliable statement. And our number one new evidence, Your Honor, in asking to vacate this conviction is that we believe the confession was likely false. And we believe that is supported by the new evidence of that IQ test. The other components are the additional alibi witness, as we stated, as well as the severe misconduct of the officers. For all of those reasons, Your Honor, we do stand by our motion. We ask that the court vacate these convictions and dismiss the case without prejudice. And of course, I'm happy and willing to answer any questions the court has.
Okay, thank you, Ms. Abramson. And for the defense?
I'm sorry, what?
I'm just asking who's going to be speaking for the defense. Okay.
I'm happy to answer any questions we have.
I'm sorry, you'll have to speak up and take your mask off. What were you saying?
Your Honor, we concur and we are prepared to answer any questions you may have.
Okay, now you're a student attorney. You're not a licensed attorney though. Okay, so do you have a motion to practice before the court?
I do, Your Honor. I do move under 8.120 that this court allow Ms. Warren to represent Mr. Webb under my supervision during this hearing.
Motion is granted.
Thank you.
You may proceed. I have to hear that and make that ruling in every case.
Thank you.
Okay,
As I was saying, we concur with Ms. Abramson and we are prepared to answer any questions you may have.
okay, thank you. Well, I do want to begin by saying, and was there anything else? I don't want to cut you off, but no?
Sure.
Okay, yes.
Do you want me to go back up to the podium?
If you're going to be out talking for a while, yeah.
Well, I don't think so. I just wanted to make sure. I know that Ms. Endler, our victim advocate, is on, and I thought there might have been a victim signed into Zoom, and I just wanted to check on the status of that if they want to make a statement.
Okay, well, this is not a sentencing.
Okay.
This is a motion. So, I typically don't open my motion docket up for victims to make statements. Ms. Endler, is there something you want to state?
Thank you,
on
Your
this
Honor.
issue?
Yeah, Sorry, this is Christine at the prosecuting attorney's office. We do have a Stephen Blasky on the phone who was hoping to make a statement. We do understand that this isn't sentencing, that it's a bit of an unusual situation. We did inform the court that we may have some potential surviving family present. So we would respectfully ask that Mr. Blasky be given the opportunity to just speak and voice his opinion on the matter.
Okay, I'd like to hear from counsel. First, is there any authority that would require this under the victim rights law?
Your Honor, I don't believe there's any authority that directly requires it. I think the victims' rights statutes, when they were created, didn't contemplate necessarily this type of hearing. And although we don't agree that the court should make their decision based on a victim impact statement, we would ask the court to allow the victim to be heard.
Okay, and for Mr. Webb?
Your Honor, we take no position. We leave it to the court's discretion.
I'm sorry.
We take no position, Your Honor. We would leave it to the court's discretion.
Okay. Well, I don't want this to become precedent that I open up my motion docket to public discourse, because I would never get through my motion docket if I did. I probably have 47 cases up on this afternoon's docket, and one can only imagine how that would go if I had a public forum on every matter. But because of the import of this matter and the length of time that this conviction has been entered, the severity of the offense, and the fact that the prosecution has requested that I hear from Mr. Blasky and the defense not taking a position, I will give him a few moments if he would like to address the court.
Thank you, Your Honor. Am I heard?
Yes, you are heard. Please identify yourself for our record.
I will be glad to do that. My name is Stephen Aaron Blasky. I am the brother of the deceased that Mr. Webb was convicted of murdering my brother, but that's not really so much why I'm here as the fact that I participated in the initial trial, in the sense that I attended it every day. Nobody in this courtroom ever did anything other than read a transcript, basically, and I was actually there, and I would like to speak to what occurred at the trial and the reasons that I disagree. I might.
Is there anything further that you'd like to say? I don't know if we've lost our connection with him or if he's concluded his remarks. He's been disconnected, not at our end. We'll give a moment should he wish to sign back in. Has he signed back in? No. Well, we don't have any indication that he is signing back in, correct?
Your Honor, I've sent him a
Oh.
text. Sorry, I've sent him a text just indicating that we've lost him and asking if I can offer any support. I can possibly try giving him a quick call, but he's using his phone to call in, so I don't know if that would be helpful.
We'll give it another minute.
Appreciate that. Thank you.
He's signing back.
Hello?
Okay.
Hello?
Yes, we seem to have lost you there. Do you wish to continue,
I'm sorry.
Mr. Blaski?
Yes, I do, Your Honor. I would very much appreciate the right to do that. I will tell you that I only heard about this meeting and that there was activity to investigate freeing Mr. Webb late Tuesday afternoon. So forgive me if my presentation lacks a little bit of organization or polish, but I will try and keep it brief. In full disclosure, I am a 1976 graduate of the University of Michigan Law School and an emeritus level member of the State Bar of Michigan, having retired more than a decade ago. In my career, I never practiced criminal law, and my only exposure to the criminal justice system was my meetings with the original assistant prosecutor assigned to this case and my attendance at every day of Mr. trial. If I use inaccurate terminology, please excuse that due to my lack of experience. What I don't want to do today is to make a victim impact statement in normal sense. Suffice it to say that my extended family was torn apart by the murder of my brother, Mark Blaski, but the purpose of this hearing, as I understand it, is to determine if Mr. Webb received a full and fair trial 36 years ago, and thus whether this court can honor and uphold the work of the predecessor trial judge and of the citizen jury who reached a verdict so long ago. Ms. Abramson gave me 90 minutes yesterday, which I appreciate, to understand this case and the prosecutor's decision not to oppose the withdrawal of the sentence. As I listened to her, my purpose was to understand her determination that the trial court's decision was faulty and that Mr. Webb was likely not guilty of the crime he was convicted of. My purpose was not to convince her that she was wrong or to seek any vengeance. I believe in justice, and that if there were solid evidence that Mr. Webb was unfairly tried and convicted, then I would believe his conviction should be overturned and he should go free. Likewise, I have no animus toward the Innocence Project. I respect their mission, and I know that sometimes trials can go wrong. I agree the system should correct these errors, and the Innocence Project contributes to that laudable goal. But in considering my comments today, I will hope you will take into account that I am the only participant today who has had any firsthand knowledge of the original trial and of the police and prosecutorial work that preceded it. Like the jurors and the judge, I saw the demeanor of the witnesses, of the defendant, of his counsel, and of the jury. Everyone here today except me is relying on dry transcript pages and on their interpretation and imagination. Your Honor, I would like to address the issues as they were explained to me by Ms. Abramson, and which she went over with you this morning. I am sorry that my efforts to contact the Innocence Project people failed because my calls were not returned, and so if they had different issues, I can't address those. Prosecutor Abramson emphasized that one of the two Washtenaw County Sheriff detectives was later convicted of criminal sexual wrongdoing and is presently in prison. That's horrible. And the fact that the perpetrator was a police officer is especially reprehensible. And she also mentioned that his partner detective had been involved in some kind of wrongdoing and had been suspended at some point from his job. This would be highly relevant if either officer's wrongful actions were in any way related to their work on the Webb case, but apparently they were not. These facts simply don't bear on this case, despite her suggestions. Prosecutor Abramson also emphasized that while the Washtenaw detectives said that Mr. Webb had confessed to murder, they never got that confession in writing or on tape. This explanation ignores that Mr. Webb was apprehended and arrested not in Michigan, but by an Ohio state trooper who was otherwise uninvolved and was unaware that there'd even been a murder. No interrogation was conducted by the Ohio State Patrol. Mr. Webb simply volunteered to the Ohio patrolman that his nervousness at the time of his arrest for DUI was not about the DUI stop, but rather was concerned about police custody because he had murdered a pharmacist in Washtenaw County, Michigan. This unsolicited confession has never been contested by Mr. Webb or by the Innocence Project or by the prosecutor. In fact, throughout the trial, neither Mr. Webb nor his private defense counsel hired by his family, it was not an overworked public defender, he had his own private counsel, denied having made two confessions, one in Ohio and one in Michigan. Instead, after hiring counsel, Mr. Webb explained his confessions by saying that he was confused by an Ann Arbor News article that he had read about the murder. That article was fully 4 weeks before he was stopped in Ohio, and he volunteered his confession. It seems strange to me that while being stopped for a DUI, the top thing on Mr. Webb's mind was an article unrelated apparently to him, which he'd read 4 weeks before in the newspaper. I don't believe that the jury believed that story either. Ms. Abramson also emphasized that her view that Mr. Webb's alibi was strong because at the trial, the defense presented the alibi. That was their primary defense, was the alibi, and it consisted of the fact that on the morning of the murder, Mr. Webb visited the Ann Arbor Social Security office. There was a witness and a document which proved that, and the fact that he was at that Social Security office was undisputed by either side. However, it was also undisputed that Mr. Webb didn't own a car at that time. He claimed that he had used public transit to and from the Social Security office. The police used the Transit Authority bus schedule and timed the trip and argued that he had time to be in both places, though it was admittedly somewhat close. It was pointed out that if he'd gotten a ride, he would have had lots of time to be at the pharmacy at the time of the murder. No one established either that he had taken a bus or that he had died. Jury heard witness and rejected by defense, which was their right. Ms. Abramson then pointed out to me that a couple of years after the trial, a private detective came forward to the family claiming that on the day of the murder, which was at that point years before, he had seen Mr. Webb at a coffee shop in Ann Arbor around the time of the murder. I frankly find it disrespectful to this court to rely on this later testimony because the Webb family brought a motion to overturn the judgment based on that later alibi testimony. The court considered the motion and rejected it. The court's decision, after full consideration, should be respected, and this failed argument should not be brought before this court again, being told that there was a strong alibi. It was fully considered by the court. Ms. Abramson told me that the Innocence Project has had Mr. Webb's IQ tested and that it is very low. In her mind, this means that there was a high probability that Mr. Webb's confessions were false confessions. There is no actual evidence of this other than the fact that he has a low IQ. The court should know that Mr. Webb's IQ may be low, but that the reason he was at a Social Security office back in the 1980s was based on years of holding down a job, which was a predicate to his later receiving disability benefits for his inability to stay sober and away from his opioid drugs of choice. Second, the defense of a false confession was proposed, considered, and rejected by the trial court. Third, Mr. Webb appeared at trial for multiple days, did not seem incompetent. He was alert. He was assisting his defense. I can testify to that because I was there. There was no evidence of a false confession presented, and there's no evidence today that it was a false confession, other than the fact that there are research studies which suggest the possibility that low IQ people can make false confessions. Your Honor, let me tell you what you haven't heard about from the defense or the prosecution. At trial, there were two eyewitnesses who identified Mr. Webb as the man they saw in the pharmacy shortly before they heard the gunshots and discovered my brother lying in his own blood. The judge and the jury and I all heard two separate witnesses who work in that building who identified Mr. Webb in a photo lineup and again appeared in open court and identified Mr. Webb. These were uninvolved citizens who came forward and were believable. No one suggested Mr. Webb's innocence talks about that at all, that there were 2 eyewitnesses and that was a major factor. The other thing you haven't heard is any new evidence. Usually when the Innocence Project proves the innocence of a convicted felon, there is some kind of new evidence to present to the court. Usually that is physical evidence, be it DNA or fingerprints or weapon, clothing, something. In this case, there is no new evidence here, save an IQ test, which certainly is not legally dispositive of the fact that the confession was false. Everything else brought to you today is not legally relevant, like a policeman's criminal conviction or an unrelated matter years after this case was closed, or an alibi witness 30 years ago, which was already considered by the court and ruled on. 36 years ago, I hoped that whoever committed this horrible crime would be convicted. I didn't know if Mr. Webb was guilty, so I attended the trial day after day to try and come to my own conclusion. I became convinced by all of the arguments for and against that he was guilty. 12 jurors came to the same conclusion. My conclusions deserve no weight because the considered judgment of 12 unprejudiced jurors deserves respect, not mine, but they came to the same conclusion, and their decision should be honored unless there is clear and convincing new evidence to the contrary. I have not heard such new evidence, and I don't think you have either. You do justice to Mr. Webb by doing justice to those he injured and to the judge and jury who passed judgment on him so many years ago. That is who deserves the respect and judgment of the court today, and I hope that the court will not take this kind of strung together list of old facts and what happened at the trial and what happened at a hearing afterwards and what happened unrelated to police officers and decide that all of that leads to the conclusion that Mr. Webb should go free. Mr. Webb received a full and fair trial. He received hearings afterwards on his motions regarding alibi, and in no case has anybody ever found there was reason to dismiss or overturn the conviction against him. I appreciate your thoughtful consideration of these points and your taking the time to listen to me. I thank you.
Thank you, Mr. Blasky. And I do want to begin by acknowledging that it must be very difficult for both the defendant, who has served 36 years in prison on this conviction, as well as for the victims' families today. Before the court is a joint motion by the prosecution and the defense to vacate Kenneth Webb's convictions for first-degree murder and armed robbery. Although the Court of Appeals previously vacated his conviction for armed robbery, for some unknown reason, an amended judgment of sentence was never entered by my predecessor. It is significant to this court that this is a joint motion agreed upon by both sides. This is rare and this is unusual. The prosecutor's office has a conviction integrity unit which has the resources to review and try and set right convictions that appear to be unjust. Defense counsel, the Michigan Innocence Clinic, is renowned for its work. Both sides have investigated this case in depth, and both sides have concluded that in the interests of justice, these convictions should be vacated. Although each of us have different roles in this process, the goal is the same for all. That is the interest of justice. Unjust convictions undermine public confidence, both in our law enforcement and in our courts. Our system of justice is not perfect because as human beings, we are all fallible, and we are reminded of that today. The first issue that the court must decide is whether there is need for an evidentiary hearing. The murder conviction was the result of a lengthy jury trial, and there were post-trial motions with additional testimony, which the court has reviewed. I do not believe that additional testimony is needed. The burden is on the defendant to establish entitlement to the relief requested. The joint motion filed with the court provides a multitude of details regarding the parties' analysis. The court will just touch on a few, as well as my concerns after review of the record. It does appear to the court that new evidence not presented to the jury that William Brady would have provided could make a different result probable on retrial. Additionally, considering previously decided claims together with this new evidence would create a significant possibility of actual innocence. The testimony of Mr. Brady would not have been cumulative because it would have covered a slightly different time period after Mr. Webb's leaving the Social Security Administration office. The investigator was certain, Mr. Brady was an investigator, was certain of the date because he was actually biding time at the coffee shop when he met with Mr. Webb, coincidentally, while waiting for his 2:30 interview with the prosecutor's office, Assistant Prosecuting Attorney James Sexsmith. It is relevant evidence. Not having just one, but two alibi witnesses, albeit a partial alibi, certainly could have created reasonable doubt for a jury to reach a different conclusion. Further, implicating statements attributed to Mr. Webb, such as the details regarding the offense, given to those investigating the crime, were purportedly made during the precise 17 minutes when the tape recording had been turned off. The fact that one detective had been suspended and demoted to that of a civilian employee at the time he testified in this case for altering a written transcript of an interview in another murder case was not known to the jury. And I know the details of that other murder case because I had the juvenile lifer resentencing. So I read the entire transcript of that trial. That serious misconduct bears on his veracity, as does the fact that the other detective subsequently lied about being a Native American to gain access to Native American juveniles in order to commit sexual misconduct on multiple occasions, one of which he was convicted of. Their veracity is important because of the testimony that defendant provided details that could only have been known by the perpetrator. After the jury had already begun deliberating, the prosecuting attorney discovered and informed defense counsel that some of those details had actually been provided. They appeared in an Ann Arbor news article. Further, the law has developed significantly in the 36 years since this conviction. There has been substantial research and developments in understanding human behavior and what might cause both false confessions and erroneous eyewitness identification. If these issues raised today were brought before our appellate courts, there is a very high likelihood that the results of Mr. Webb's prior appeals would have been different. There were other issues during the proceedings that were very concerning, such as when a relative was wearing a 3 by 5 inch photograph of the victim and the victim's son on his suit coat in full view of the jurors. Although this may have been his silent memorial, it certainly could have influenced the jurors walking past him in the hall or seeing him wearing it in the courtroom. A court officer testified at a later hearing that a relative wearing that 3-by-5-inch photograph tried to talk to a juror. The trial judge stated on the record that it was very, very regrettable and that the court was very upset and spent a lot of time on that on the issue of the relative wearing the photo during the proceedings. One juror was actually excused as a result. Further, after trial, it was discovered that that relative wearing the photo had approached the critical Social Security Administration independent alibi witness, telling her that her testimony might let a drug-addicted murderer off. She testified later that she believed that her testimony before the jury was affected by that interaction because it made her nervous and understandably upset. During police interviews, the defendant was under the influence of alcohol, other substances, and/or sleep deprived. He had a long history of mental illness, and defense counsel did not have his psychiatric from the Ypsilanti Regional Psychiatric Hospital until the day of sentencing. It confirmed poly drug abuse. Although we do not have cognitive testing from what his IQ would have been at the time of the offense, the recent testing reveals that at least currently it is below borderline intellectual functioning. I'm not making my decision based on that fact because we don't know what it was 36 years ago, but it is just one additional factor that the court does consider. But all of these issues combine to make the court conclude by clear and convincing evidence that Mr. Webb did not get a fair trial. And with the new evidence, a different result is probable. Also, previously decided claims, when considered with this new evidence, create a significant possibility of actual innocence. Accordingly, these convictions are vacated without prejudice. And I am signing the order that was presented. Thank you, and that concludes this hearing.
Thank you, Your
Thank you,
Honor.
Your Honor.
Sure.
Just to be clear, the case is dismissed without prejudice?
Yes.
Okay. Thank you so much, Your Honor.